The Aged Care Act primarily regulates the conduct of registered providers. However, it also imposes specific obligations on the conduct of those working in the sector. So this includes aged care workers as well as, of course, responsible persons. So both aged care workers and responsible persons have to comply with the Aged Care Code of Conduct. So, in terms of what this really looks like for responsible persons must take steps to ensure that they comply with the Code of Conduct, including, of course, most importantly, reading and understanding the code. The code itself is quite straightforward and is really the sorts of things you would expect. It's less than a page in length, so it's not a lot to get your head around. However, you should also familiarise yourself with the guidance issued by the Aged Care Quality and Safety Commission on the code. There is a guidance document that is well over 50 pages that the Commission has issued for providers as well as for responsible persons. So you really need to have a look at that, ensure you understand how it is that the Commission sees the code working in practice. Responsible persons also need to take steps to ensure that the organisation is complying with the code and that the workforce is complying with the code. So that includes providing training, providing copies of the code to your workforce, and don't forget this will include your contracted workforce, and of course, providing them with the Commission's guidance on the code. So what happens if a person breaches the Code of Conduct? Well, in that case, the Commission can investigate, and if they find there has been a breach, they can issue a caution letter, or in severe cases, they can impose a banning order. Interestingly, the Commission has already issued quite a number of banning orders since the code was first released a few years ago. And there are lots of names on that register, and it's growing all the time. As a firm, we typically act for providers rather than individual workers. So we haven't necessarily been involved in the cases where the Commission has been investigating a worker. And the banning register itself doesn't really tell you the sorts of things people are being banned for. However, we suspect it really is for that very severe misconduct. So things like assaults or, theft or deception and things like that, rather than lower level mistakes. The Commission can also apply to a court for them to issue a civil penalty order or a fine against a provider or a responsible person or a worker who fails to comply with the Code of Conduct. However, we haven't seen them use that power yet. Again, it's possible they may do so, but when they have the ability to issue a banning order and stop someone from working in the sector, that may be sufficient for them. The other specific liability for responsible persons is that they are subject to the new statutory duty. This applies to all responsible persons who are at the senior level within an organisation, including those on the governing body, as well as members of the executive. It doesn't apply to your service level managers, such as a facility manager if you're in residential care, or the branch manager. The statutory duty is quite complicated, so I don't want to go through it in too much detail as it really is very legalistic and wordy. However, in a nutshell, the duty of a responsible person is to exercise due diligence to ensure that the registered provider complies with its statutory duty. So, what is the provider's statutory duty? It's a duty to, as far as reasonably practicable, ensure that its conduct does not cause adverse effects to the health and safety of individuals to whom the provider is delivering aged care services. The term reasonably practicable is defined in the Act, and it's really about taking into account all relevant matters, such as how likely it is that the adverse effect would occur, how harmful that adverse effect is, what the person knows or reasonably to know about ways of preventing that effect, and the availability and suitability of ways that there are to prevent adverse effects, as well as taking into account the rights of individuals under the Statement of Rights. And so I think what this is about is recognising that there may sometimes be ways of preventing risk. For example, let's just stop anyone doing anything that's risky at all. But of course, we know the Statement of Rights recognises the importance of people being able to exercise choice and to make decisions about how they want to live their lives, even if that involves some risk. As I mentioned before, the responsible person's obligation is to exercise due diligence to ensure that the provider complies with its statutory duty. So, what does due diligence mean for you as a responsible person? Due diligence is defined in the Act, and it includes taking reasonable steps to acquire and maintain knowledge of the requirements that apply to your organisation under the Act, to gain an understanding of the nature of the funded aged care services that your organisation delivers and the potential adverse effects that can result to the individuals you provide those services to ensure that the registered provider has available for use and that it does use appropriate resources and processes to manage adverse effects to the health and safety of individuals who are accessing services, to ensure that the registered provider has appropriate processes for receiving and considering information regarding incidents and risks, and of course, for responding to that information in a timely way. Ensuring that the registered provider has and implements processes for complying with the requirements of registered providers under the Aged Care Act. Now, it's important to be aware that not every breach of the duty will result in a penalty. A responsible person or the provider itself can only be found liable if they engage in conduct that doesn't comply with the duty, they don't have a reasonable excuse, and also that their conduct amounts to a serious failure to comply with the duty. That term is defined in the Act, however, again, very lengthy, so I won't go into it, but it really just is important to understand that the penalties under the Act are really going to be reserved for those more serious failures to comply, not your average sort of compliance issues that occur from time to time. Overall, I'd like to stress that based on my experience, these statutory duties are likely to be used as a last resort by the Aged Care Quality and Safety Commission. As I mentioned earlier, the Aged Care Quality and Safety Commission has a range of regulatory powers available to it, and it will really only seek to prosecute either an individual or a responsible person where they identify particularly egregious breach of the statutory duty, or perhaps, for example, if a provider has done something very terrible and then exited the system and there's a sense that they got away with it.